Hello, my name is David Sampedro. I'm a board certified civil trial lawyer with the law firm of Panter, and Sampedro here in Miami, Florida. Today I want to talk to you about one of the basics in bringing forth any type of lawsuit and some of the limitations that surround it, specifically time limitations, known as a statute of limitations. And this basically is a time period imposed, at least in Florida, by statute, where a plaintiff has a certain amount of definitive time to bring forward a lawsuit against a person that they believe is responsible. So the reason behind this law is that it's believed to be good public policy for defendants or potential defendants to have a definitive time period where they can put their actions behind them and that everybody can just move on. Specifically, our law firm typically deals with cases of negligence, medical malpractice, those types of cases, and I'll talk to you a little bit about that. At least in Florida, if somebody is hurt as a result of the negligence of another person, the statute of limitations typically is 4 years from the time that the person was hurt or was injured. In other words, you have 4 years from the date that the injury occurred to bring forward a lawsuit. If you don't do so, and when I say lawsuit, I mean a case filed in court. If you don't do so, your claim will be forever barred. There are some situations, for example, in medical malpractice cases where it's a little bit more complicated. There we have a rule that's known as a 2-4-7 rule. And that basically what that means is that you have 2 years from the date that you knew or should have known that the malpractice occurred, but in no event can that time period be more than 4 years from the time that the malpractice occurred. And there is an exception which is very rarely used, which goes to 7 if there's some sort of fraudulent concealment to prevent the plaintiff from finding out that the malpractice occurred. But I'll give you an example of the 2 and 4 rule. Let's say, for example, you were to have surgery and a surgical instrument was left inside of you for one reason or another. You would have 2 years from the date that you knew or should have known that that surgical instrument was left inside of you. But for example, or as an example, if you found out 4 years and a day later, for example, you had abdominal surgery and some sort of instrument was left inside, and 4 years and a day later you had an x-ray and that was the first time you discovered that that foreign body was left inside of you, well, you would be barred from bringing a claim. Obviously that doesn't happen too often, but it's something for you to consider. The last thing I'll mention is that there are some circumstances where by contract or by agreement or perhaps even by a ticket that you purchase where the statute of limitations can be further reduced. So you have to be very well aware that sometimes tickets that you purchase might limit the time period for you to bring a claim, which normally would be 4 years, down to 1 year. And the last comment I'll bring up are cases of wrongful death. And in those situations, the time period, the statute of limitations, is 2 years. But I do want you to keep in mind that there are some circumstances, perhaps by your own agreement, and that agreement could be just by, again, purchasing something. You can actually further restrict the statute of limitations and further restrict the time period that you have to bring a claim and present it in a court of law the type of injuries that you've sustained. Thank you.